Ms Murphy, before we resume, could I just formally welcome Judge Chattard, who I think is visiting us from France today as an observer as part of our international programme. I know that you will make him very welcome. Yes.
Thank you, my lady. Before moving to Hall and Simmons, can I ask you to note that paragraph 23 of our skeleton argument in Core Bundle 110,
Yes.
we've set out multiple references in darker to the immunity not extending to general prosecutorial functions, law enforcement functions, and so on. So just that you have all of those references.
Paragraph
23.
of your skeleton.
Yes, my
Thank
lady,
you.
there's multiple instances of that observation being made in dark, so
Yes.
I don't trouble you with them now. But moving on to Hall and Simmons, I'm pausing for a moment to consider what was understood of the immunity of advocates at that critical point in time before the House of Lords gave consideration to advocates' immunity in that seminal case.
Yes.
And the definition was described at that snapshot in time before Hall and Simmons as being an immunity enjoyed by a lawyer acting as an advocate, being immune from any claim for damages for negligence by a client, but I think we'd agree it's certainly broader than that. But the critical, at that stage, the critical phrase was arising out of almost anything done or omitted in the course of conducting a case in court. And Mr. Justice Ritchie sets that out as a foundational definition in his discussion of this aspect from paragraphs 81 in his judgment.
Yes.
Where does that come from?
It actually comes mostly from Lord Bingham in the Court of Appeal in Hall and Simmons.
Oh, okay.
Mr. Justice Ritchie spent some time with what Lord Bingham had to say in the Court of Appeal in Hall and Simmons, perhaps unusually, but it was, as is not to be, as is unsurprising in respect of that particular jurist, it was very helpful scene setting for the judgments
The
of the Lords.
paragraph in Mr. Justice Ritchie's judgment is.
Paragraph 81.
Thank you very much. That's fine.
Thank
That's
you,
all I
my
need
lord.
to know, yeah.
And which bits of Hall and Simmons do you want us to look at?
Yes, so just a couple of remarks before we dive into the details. So first of all, the justifications for an immunity of that breadth was clearly found to no longer be present. In the words of my lady, the President, things had moved on. But the fact that they had moved on begs the question. It doesn't answer the question. My learned friend, Ms. Barton, King's Counsel, describes Hall and Simmons as imposing a limitation on advocates' immunity. But we disagree. Properly analysed, the scope of the immunity that survived, it did not survive unaffected, save for a carve-out.
Sorry, I'm not following you. Who described it as a limitation?
My learned friend, Ms. Barton, King's Counsel, for
Right.
the second appellant.
You say properly, it's not a limitation on an existing immunity. It is what?
My lady, apologies. The point I'm endeavouring to make is that the scope of the immunity did not come out of Hall and Simmons unaffected, save for a carve-out.
Right. Before Her Honour Judge Brownhill, the contention was Hall and Simmons had removed advocates' immunity altogether. We've moved on, and now your position is that clearly Hall and Simmons identified or declared that clients could sue barristers for negligence in court, but you say its effect went wider than that in that?
Well, my lady, let me take you to the passages, but the proposition I'm endeavouring to make good by reference to them is that it was only, and I'm just double checking that I'm getting the right, it was only Lord Hope who considered that the the taking away of immunity of advocates in Hall and Simmons was limited to suit by one's own client. He's the only one of their lordships who say that explicitly.
And what did the others say?
With regard to the logic of the reasoning of the three justices in the majority, it's implicit in their logic that it falls for all purposes in our submission.
Say again.
Falls for...
That it falls for all purposes, save where it is within the parameters of witness immunity.
Falls for all purposes save...
For witness immunity. So you say advocate's immunity has gone?
I do, and I will not only not rely on myself for that proposition, my lady, Jones and Caney, to see why we rely on that as being...
Mr. Justice Ritchie found it hadn't.
Yes.
And there isn't a cross-appeal or respondent's notice.
My lord, the reason why, as a matter of procedural practice, we haven't entered a respondent's notice with regard to that finding is that Mr. Justice Ritchie found that these events, at least arguably, did not fall within the scope of an existing immunity. And to the extent it appears I misunderstood the original appellant's notice, we entered a respondent's notice which helpfully fleshed out.
We have got bundles and bundles of authorities, and it doesn't mean that you are wrong by any means, but has anybody other than you ever suggested that the effect of Hall and Simons was to remove advocate's immunity altogether?
In this appeal, no. In
Okay.
Jones and Caney, yes, their lordships, and I'll take you to those passages.
You say in Jones and Caney, the House held that...
Well, no, the House helped with the interpretation of Hall and Simmons in identifying that it had swept the immunity away completely.
And has anybody other than yourself in this litigation ever contended that that is the effect of Hall and Simons because of Jones and Caney?
Well, I don't put it because of Jones and Caney. It's
No,
an
but you
interpretive tool.
Any academic literature
No, well, it's,
that has ever suggested this?
no, my lady, the issue has only ever arisen since Hall and Simons, in my submission, in respect of facts that are full clearly within witness immunity. So it hasn't arisen.
No, it's an old case, 25 years ago. It's quarter of a
Exactly,
century.
and that is an
And so in this quarter of a century, this issue has never arisen in the sense that anybody's ever suggested what you're now suggesting.
It's an illustration of how difficult it is to either access justice or articulate a coherent claim outside the scope of witness immunity, but nevertheless relating.
Right. Anyway, we've taken up enough of your time. So,
And it's also Daniel's, my lady, to the extent that the immunities are overlapping, as we say they are.
right, so headline submission, only witness immunity has survived Hall and Simons.
Well, of course, my lady, all I need to satisfy you of is that I've got an arguable
I
case
understand.
in relation to advocates' immunity not being of the breadth for which the appellants contend. And myself and Mr. Justice Ritchie agree on that, which is why there's no respondents' notice. My lord, my lady, therefore, we take you to that critically important passage in Lord Hoffman's speech, and this is in the authorities bundle at 453. Beginning at really from the witness analogy all the way through to the next topic, which is collateral attack. And this speech is obviously one with which Lord Brown Wilkinson and Lord Millett agree, that drawing of a close analogy between the immunity of advocates that have been recognised to that point and witness immunity.
Yes?
And what we see there is that advocates' immunity being found not to be justified by an advocate having the confidence when she or he rises to one's feet.
Sorry, where are you reading from?
My Lord, I'm actually summarising that what we take from that quite lengthy passage.
What, paragraph 18?
Topic 18.
Right.
And we see at H, at the bottom of page 453, that Lord Hoffman is extrapolating that the dicta of Taylor is that the immunity is limited to cases in which the alleged statement constitutes the cause of action, a refrain you've heard from me repeatedly today. Not sufficient, we see over the page at 454, to explain any immunity relating to court proceedings by saying that the people involved should be free from avoidable stress and tension. It's another version of the vexation argument, which I have already rejected, and which two of their lordships agree. And that point with which we strongly align, how would he otherwise behave differently in a way which was contrary to the public interest? Point we were making in respect of the inquest example before lunch. And we also rely on Lord Stein's remarks.
So can I just be clear, in respect of Paul and Simon's, the only paragraph you're relying on is effectively to support this aspect of evidence, paragraph 18, is that right?
I'm relying on topic 18, the witnessing.
Topic 18, yes.
And every aspect of it.
Right.
To make good, one hopes, the contention that in Lord Hoffman and Lord Brown Wilkinson and Lord Millett's analysis, the witness enjoyed, the immunity enjoyed by a witness to that point and an advocate to that point were essentially springing from the same source and were bound by the same parameters. And that is the basis upon which all three of their lordships, in the majority, go on to analyse why it is no longer necessary. And
Well, you'll show us a passage that says that in terms, won't you, at some point?
that tells you that they say it's no longer necessary.
Yeah,
Yes, certainly, my lord.
because the proposition that all these points go to is that advocates' immunity has fallen away
Completely.
completely.
Well, let me take you to a helpful summary in the speech of Lord Brown Wilkinson. For the most part, he relied on the speeches of Lord Stein and Hoffman, but explains at page 440 at C what all their lordships agree upon and what they disagree about.
440,
Yes.
Lord Brown Wilkinson. Letter
Yep.
C to D.
C to D.
it is understood by everybody that the key word here is the word negligence, because that encompasses claims by clients. That's what the context of all of this is. So it's claims by clients, not by third parties, in the tort of negligence.
My Lord, we rely on a very particular distinction where references in the majority speeches talk about negligence, which would obviously, without, unless qualified, include third-party claims in negligence, whereas it is only Lord Hope in the minority who addresses his view, explaining his reasons why it is limited to the suit of one's own client. My Lady, we can see that in Lord Hope's speech, where he retains the immunity of the advocate against claims for negligence by third parties, and that's at page 481 of the bundle, letter A. And of course, his dissent was a material dissent for the purposes of this appeal, because he did not consider that there should be any abrogation of the immunity of an advocate in criminal proceedings. Lord Hutton's dissent in respect of the advocate in criminal proceedings, in broad terms, was relying upon the unscrupulous characteristics of criminal defendants and what that would mean for vexatious litigation. And we can see that, for example,
Right, I'm just reading, I think this is all very helpfully set out in your skeleton, isn't it, at paragraphs 26 to 28. And do I understand you, by those paragraphs, to be accepting there's immunity in respect of defamation claims? Advocates' immunity in respect of defamation claims?
because the claim would be on the content of the statement. So yes, absolutely.
But otherwise, your contention is, per paragraphs 26 to 28, no advocate's immunity anymore, except otherwise.
Well, my lady, we've looked at various authorities that explain that where there is an ingenious attempt to reframe the cause of action to be, in substance, a claim in defamation, but styled as, for example, a conspiracy to injure, or also this has arisen in the harassment cases, where the allegation relates to what's being said in the statement, the advocate, every participant in judicial proceedings, retains their immunity. To complete my remarks with regard to Holland and Simmons, and this is for completeness, although Lord Hobhouse, also in his dissenting judgment regarding criminal proceedings, does not expressly state that the immunity that he was willing to see taken away from civil proceedings was retained for third parties. He does use logic which focused upon the separate position of the advocate's own client. So one could, if one was being conservative about it, put Lord Hobhouse in Lord Hope's camp in relation to retaining the immunity in respect of suits by third parties. So far as Lord Hobhouse is concerned, in removing the immunity in civil cases, he was heavily influenced by the strictures of the Bolam test. We see that at 493 in the bundle at H. And interestingly, and we do say this is interesting, by what Lord Hobhouse considered to be an absolute immunity barring any claim in negligence against the Crown Prosecution Service in the discharge of their prosecutorial functions, which we are now all educated and informed by the Robinson, Michael and Poole authorities.
Where are we looking in Lord Hobhouse's judgment?
Lord Hobhouse at 493 in the bundle at H.
493 letters.
H.
That's telling you what a negligence claim is.
Yes, and what he's saying there, my lord, is that the sky is not going to fall in when people can start suing their advocates, because the strictures of the Bolam test, allied, as we see elsewhere in the judgment, with the muscularity of the Part 24 and Part 3 procedures in respect to summary judgment and strikeout, respectively, will weed out unmeritorious claims. And elsewhere in the speeches of the Lords, we see lots of consideration of the checks and balances within the system, which will ensure that the vexatious claim consideration that arose in centuries past is not going to need to be of such a concern by the time we get to Jones and Caney in 2000 and I believe it was 2. And we see that reviewed then in Jones and Caney 9 years later, and we see that which was predicted has in fact come to pass. There are 2 reasons, likely as not, why an appellant has not come before this court, nor do we see in the appellant court. The issue has been raised previously, for sure, but the circumstances in
And
which...
where has it been raised?
The issue of a claim against an advocate other than by his or her own client. I mean, obviously that's the largest category of case for obvious reasons. So far as third-party liability is concerned, the hoops which a third-party litigant has to go through are obviously much more serious than an own client. There's no obvious duty of care. It has to be based on an assumption of responsibility. And clearly these facts are unusual, happily, because they are very serious facts with really serious consequences. My lord, my lady, if I could take you next, please, to Jones and Caney and the speech of Lord Phillips at 689 in the bundle. Now, what is telling, we say, from Lord Phillips' summation? Obviously, Hall and Simmons was a case about negligence, so it was only addressing immunity in the context of negligence. But what we say is material is that when Lord Phillips comes to summarise what has been swept away, it is the advocate's immunity from liability and negligence. And we consider the absence of Lord Hope's formulation of liability and negligence on suit of one's own client is an eloquent omission. That what he's concluding there is that it's gone for negligence. It's not gone for defamation. It does beg the question, what's left? And we say that it is arguable, at least, that when the cause of action does not relate to the evidence, it has also gone.
And where do we find that in Lord Phillips's summary?
Lord Phillips in Jones and Caney was considering only the perspective of an expert witness. So he,
Well, I know. So it's even further removed than Hall and Simons, because Hall and Simons is the advocate. Jones and Caney is an expert witness.
absolutely, my lord.
And it is, again, negligence, because that was whether an expert could be sued in negligence.
Yes. No, my lord, I don't put it any higher than this. It's a short point that when Lord Phillips came to summarising what had occurred in Hall and Simmons, he described it as the sweeping away of immunity of advocates in respect of negligence.
The whole, anyway, I think we have your submissions, but the whole rationale behind Hall and Simons was the fact that the duty of care was owed to the client, who should therefore have a remedy.
My lady, I very respectfully disagree.
Right?
From the passage in Hall and Simons from Lord Hoffman that we've drawn as being of critical importance,
Yes.
we're looking there at why an immunity should exist. And we say that none of the reasons established, addressed, or analysed there or elsewhere at any point in Hall and Simmons gives rise to a logical distinction between the immunity falling away in negligence, but not in respect of the type of claims for which this respondent seeks a remedy. Of course, the focus was upon that particular cause of action under consideration, but there's nowhere in the speeches of the majority that tells us anything further as to this category of case, but does help as to whether there is a public policy justification for an immunity in this category of case, with their careful analysis of the competing public policy justifications. Before moving on to Singh and Reading, and perhaps most importantly to Singh, to Daniels, I want to further emphasise the point that, especially that point from, especially Lord Hoffman's speech in Hall and Simmons, that when you look at these cases and they're looking at their nature, it is difficult to discern a distinction between witness immunity and advocate's immunity, whether when their lordships are analysing purpose, impact, consequences of removal. These two immunities, we say they were always essentially the same immunity that protected participants in the judicial process. As we work through these authorities of this century, that's becoming even more apparent. And so we go to Singh and Reading, and the judgment of Lord Justice Lewison, Core Bundle 819.
Tab. Tab. 31.
The redlining in respect of this begins actually at 818. But we submit that the nub of it is set out succinctly at paragraph 46. And that supports our contention. It can no longer, in my judgment, be said that immunity from civil suit, quote, attaches to anything said or done by anybody in the course of judicial proceedings, whatever the nature of the claim made in respect of such behaviour or statements. And we see in the discussion
And that
above,
must be right because of Hall and Jones and Caney,
and Heath,
which he's already set out. So he's summarising the consequence of Jones and Caney. It can't be said that it attaches to anything said and done. We know that because of Jones and Caney and Hall.
my lord, yes, and therefore,
It's not saying the immunity's gone. It's just as it can't be put in those wide terms.
no, precisely, and my lord, I apologise if I'm not making this crystal clear. We say, and I have got my concluding section is about definitions, and that may help to make my submissions clearer. But what is being explained here is that because the policy of the immunity is to encourage freedom of expression, and because, for example, in Hall and Simmons, the majority and the unanimous view of the Lords so far as civil proceedings is concerned is that, properly analysed, there is no public interest in affording to an advocate a sense of certainty as to what he or she will or will not be sued for when he or she rises to his or her feet. And we know from the multiple citations already offered is that what clearly remains is where the alleged statement constitutes the cause of action. And there are slim pickings as to what advocates' immunity might be, as we can note from Ms. Barton King's Counsel's submissions yesterday. We say there's good reason for that. It's been essentially, for all purposes, swept away and left with this kernel of witness immunity, so it hasn't had to be debated. But we know what it isn't. We know what it is. And we say within, and Mr. Justice Ritchie is very clear on this, that in the territory of the facts that arise in this case, it's unclear whether the activity, and we emphasise the activity of failing to retain the confidential information, the administrative activity of completing a contact card for administrative purposes, it is at least arguable that what's left after Hall and Simmons, after Jones and Caney, after these, after Darker, is not comfortably protecting this tortious contact.
I mean, I've got very much got an eye on the clock, but I am struggling with this, and it may be that we just need to go away and consider carefully these submissions. But we know Darker was handed down 7 days after the judgment in Hall and Simons, don't we?
Yes, we do.
And we do know that they're overlapping constitution. And we
Yes.
do know that Darker, the Lord Hope in Darker expressly confirms the core immunity for advocates.
Yes, my lady, but he's not disagreeing with what Lord Hoffman, oh, sorry, I apologise. Let me just,
So 7 days later, Lord Hope's in both houses, and just confirms in terms, page 327.
yes,
Absolute immunity, shared by witnesses. Same immunity is given to the parties, their advocates, jurors, and the judge.
Yes, my lady, and we say that
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 what? That,
statement of Lord Hope
yes?
has to be understood in relation to what he also says at page 329 of the bundle between C and F. Crucial difference between statements made prior to giving evidence and things said or done in the ordinary course of preparing reports for use of evidence, and so on.
Right, anyway, you've dealt with
So
sin.
we, we say, my lady, that the passage to which you're referring supports what we're saying, because it's Lord Hope saying witnesses, advocates all have the benefit of the same immunity in the context of their engagement in judicial processes. And then going on at 329 to draw the distinctions between the evidential and the investigative/administrative process. And that's precisely how we put our case on behalf of XGY. My lady, so far as Crawford and Jenkins is concerned, and this is at tab 32 in the bundle, a judgment of Sir Timothy Lloyd, with which my lady, the President, agreed. I make a brief mention here with regard to this matter, because we can see from bundle page 841 at paragraph 54, quite proper consideration of the availability of alternative remedies when considering whether it is appropriate to uphold an immunity. And we see there, arising from the clarification of the House of Lords in Martin and Watson in 1996, that it is pertinent to locking out a litigant from a claim in respect of statements in the judicial process, that such a litigant, as clarified in Martin and Watson, has a claim for malicious process if that litigant can establish that the witness set the law in motion. And so to the extent that Munster and Lamb is saying you can't bring a claim against a malicious witness, even where there's an absence of probable cause, it looks likely, although I don't put it any higher than that, that that was because back in those days it was the prosecutor, and I think all the way up until the point in time in which the House of Lords clarified the position in 1996, claims against witnesses for malicious prosecution were not considered possible. We've not got that clear set of criteria for a malicious process claim against a witness. And that was considered material in blocking out, extinguishing, barring the claimant's remedy in respect of that element of the complaint. And similarly at paragraph 55, that because the statement, the harassing statement as it was pleaded, had led the police to arrest the claimant, it was also noted and considered pertinent that a claim in false imprisonment lay against the police and did in fact succeed in respect of one element of the alleged harassment. And we also note paragraph 70. The conclusion that there was no reason to see the harassment as any different from a claim in defamation, and therefore falling within the witness immunity rule. And there's a corollary between those remedies, the malicious process remedy, the false imprisonment remedy against the police, with the responsibility of the judge to regulate proceedings and to rely on matters such as contempt of court and addressing perjury and so on, all matters which are protective within the judicial process by the nature of its consideration of the evidence and absent from what occurred in this instance. I turn next to Daniels. This court considered there in...
Tab.
Oh, I'm so sorry, my lord. It's tab 34, page 882,
Yeah.
which places it in volume 2. This court considered there in detail the competing submissions as to the scope of the immunity.
Of the witness immunity.
No, in this instance, participants in court proceedings, my lord.
The police officers involved in the Lynette White case.
Yes, that's right, my lord. But as it was put, and I can take it a little bit more slowly if it assists.
So it's the investigating officers and the claims were unlawful detention, malicious prosecution and so on. Yeah,
And the concealing, destroying and withholding of documents.
yeah.
That was important to the trial. And the destruction of documents. And we can see
And then 32 starts the scope of the immunity variously described in the authorities which is enjoyed by a witness.
yes, my lord, could I draw your attention to paragraph 16?
Yeah,
There is such a close analysis of what one might call judicial proceedings immunity, and through the funnel of witness immunity, that this discussion, we submit, is highly pertinent because the Chief Constable was contending for a wide immunity, submitting that it applied to participants in criminal proceedings where the function is intimately associated with the judicial phase of such proceedings. Extending to statements made out of court, which could fairly be said to be part of the investigation of crime with a view to prosecution, and thus to written statements in schedules of unused material served in the criminal proceedings. So the argument being advanced was the Chief Constable was that that intimate connection brought within the cloak of immunity administrative and investigative actions, including the preparation of schedules of unused material. The officers submitted that the immunity was limited to the giving of evidence and did not extend to the actions of police officers who deliberately or recklessly failed to make proper disclosure or who provided misleading disclosure. We can see that at paragraph 32. My ladies, my lord, speaking personally, I find the judgments in this particular case to be especially helpful. Lord Justice Lloyd Jones' analysis to be especially helpful when considering this case. It is especially helpful because it brings into focus the immunity that does attract and from which to the actions of a prosecutor and why. And we say it is singularly helpful in respect of our claim against the second appellant, but it is extremely helpful, and we say determinative of the first appellant's appeal. Because what Lord Justice Lloyd Jones did was rely on illustrations of where the boundaries lay, taking those from Singh and Smart, which might be considered to be pure witness immunity cases. But here, when looking at prosecutorial and investigative functions, concluded at paragraphs 40 to 41 that the immunity did not extend to conduct unconnected with the giving of evidence or the making of statements. And we rely on that passage, those paragraphs, I apologise. Again, relying on Heath.
Well, we've looked at these, haven't we? 38 to 40.
I haven't made a note that we have. Do you mean yesterday, my lord?
No, we looked at these with you this morning.
Oh, we did, my lord. I'm so sorry. Yes, you're quite right. I was taking there. I went there.
I have short-term memory issues, but not that bad.
Well, clearly, mine are being exposed, but again, I pray for heat. And so we submit, and here we rely on paragraph 42. And we would ask you to read through to 46, whether now or in your own time, that the fact that an activity is intimately associated with the judicial phase of a criminal process does not of itself necessarily give rise to the immunity. Going back to 42, it's all about the evidence. So whether you look at it from the point of view that Holland Simmons swept advocates' immunity away, my personal analysis, or you look at it from the point of view of whether the advocate's immunity, as explained for us in Daniels, sits within the parameters of witness immunity, it essentially comes to the same answer. And the mere fact that there is an even intimate connection is not enough. And we say nothing to do with the evidence, so therefore, at least arguably outside the scope of an existing immunity. It might be convenient at this moment to turn to the consideration of definitions. And we have at page 113 of the core bundle, the first appellant's skeleton argument. Bear with me a moment.
113,
Oh, apologies.
that's your skeleton.
Yeah, sorry, it's 38, page 38. And we see there a definition of what is this immunity, and it's described as attaching to anything said or done in court unless wholly extraneous to the functions of the individual in the proceedings, extending to things said and done outside court so far as it is necessary to ensure that core immunity cannot be circumvented. Similarly, the advocate encompassing their words and actions in all preliminary hearings, and including the person who prepares the court file for the advocate or provides information to the advocate for use in a court hearing. And so far as witnesses, essentially everything unless wholly extraneous to the evidence. We say that that extremely expansive form of definition of the immunities is necessary to capture under its umbrella the events that occurred in relation to the respondent. But we say, particularly when...
The events so far as both appellants are concerned.
Yes, my lady. I plan to come to the second appellant's definitions in just a moment. My learned friend, Mr. Birking's counsel, talked about the, quote, potential, unquote, deployment of the respondent's confidential location in the bail hearing. And we say potential deployment, absolutely not sufficient to capture within the scope of either advocates or witness immunity, and certainly not the first appellant's ability to piggyback on any immunity, an element of the proceedings that was so detached from the evidence. Mr. Birking's counsel said, my notice is imperfect, so no doubt it can be corrected by my learned friend. But my note is that he described as falling within the scope of the immunity all of the evidence provided by the investigator to the advocate for use at the bail hearing, which must include the victim's details, material that could potentially be deployed in the course of the bail hearing, whether as evidence or not. And we say, look at Daniel's in particular, but also darker, and that cannot be right. So far as the second appellant is concerned, their definition is set out in at page 68 of the core bundle.
Sorry, their definition.
Yes,
Yep.
of the immunity.
Yes.
At little a. Again, very broad. The immunity bars any cause of action based on things said or done by an advocate in the course of court proceedings, including claims arising from information disclosed or things said in court. And further, cannot be sued for anything said in court, applying to all causes of action, and they say because of the nature of the rationale. And we say that can't be right. that the immunity of a participant in the judicial process is limited to the evidence, whether in its preparation for court, its admission in court, or its discussion in court. And that there is nothing in any of the authorities that supports immunities of the breadth for which my learned friends on behalf of the appellants contend. And that the facts of this case fall without the clearly defined immunities, and it is therefore necessary, as Mr. Justice Ritchie did, to say, is this necessary? Is there sufficient public policy justifications for it? And for the reasons Mr. Justice Ritchie gave, but in particular because of the analysis of the House of Lords in Hall and Simmons, clearly it is not justified.
Right. So is that the legal landscape?
It is, and I have very few remarks on summary judgment, which I can do in a few moments.
Good, and then I think we'll have a short break. Thank you. Yes.
So far as the summary judgment argument is concerned, and Mr. Pohl does not address you because the points were much more enmeshed through our submissions. We have, obviously, Mr. Justice Ritchie's analysis at paragraphs 120 through to 126 and 135 to 136 of his judgment. We say there was an error of law in Her Honour Judge Brownhill's assessment that an absence of a recent manifestation of the risk was material, because that was to confuse the concepts of present and continuing with recent risk, and that there was, in her judgment, an unreasonable equating of the statement signed on behalf of the first appellant, in which it was asserted that there was no longer a present and continuing risk on the 19th of November, with the objective test that would need to be satisfied in relation to the respondent's claim that she was in fact at real and immediate risk. And that it is entirely unattractive for the defendant to put forward a statement with that bold factual assertion without providing us with the disclosure. And on this aspect, we are particularly aggrieved that we know nothing about what the police knew about DYP, his antecedents. There appear to be traces of him going in and out of prison at various times. We don't even know if during the periods of time when he was aware of the respondent's location, he was in a position to threaten her or to act upon his threats. He was also evading police. So the whole thing is entirely obscure. We don't even know who was telling what to who when. So far as the Article 3 severity standard is concerned, it is an area of law that has quite a lot of authority underpinning it, but in a nutshell, assessing the severity threshold under Article 3 is highly fact-specific. Where the Article 3, the treatment in violation of Article 3 carries alongside it an element of discrimination, as on the European authorities it invariably does when we're addressing gender-based violence, which under the Convention is defined as a form of discrimination, the threshold is in effect lowered. And as we heard yesterday, it clearly doesn't have a simplistic tick box exercise. Was there ABH? Yes, therefore it's Article 3. No, therefore it isn't. And we've set that out more fully in our skeleton at, pardon me, actually, that's not the reference. Yes, we can see that actually in DSD in the Supreme Court, and the analysis there at 1278 of the bundle.
Sorry, DS. What's the reference?
Yes, it's DSD in the Supreme Court, authorities bundle at one. The authority begins at page 1236, and the threshold is set out at the bottom of page 1279 into 180.
Thank you.
And so far as Article 8 is concerned, we simply draw the court's attention to a recent judgment of Mrs. Justice Hill in SZR and Blackburn, and that's the Authorities Bundle, Volume 4, tab 50, and the Article 8 point is dealt with at 1626, and in essence is supportive of our contention that the respondents' claims in respect of breach of the operational and system duty under Article 2 and Article 3 are separate and distinct from the Article 8 claim in this matter, which posits a direct violation, not a failure to protect from a violation, of the rights protected by Article 8. And so, for example, we emphasise the element of rendering the respondent homeless. And so there are elements of the Article 8 claim which leave it standing separately from the Article 2 and 3 claims. They don't just go together as has been submitted. And so far as the easy air principles are concerned, and I am about to sit down, the evidence, no, actually, I think I've probably dealt with this, because the points I'm making about what we don't know around the system failing and what we don't know around DYP's background, they also go to the easy air summary judgment and strikeout positions. But of course, you have our point regarding the compelling other reason, which has perhaps been demonstrated by the nature of the discussions over today and yesterday.
I thought you were going to say that at some stage. Thank you very much indeed.
May I help, if I may help?
You've been very patient and helpful in answering the many questions that we have been firing at you, and I know it's been hot as well. So thank you for that.
Right.
Just going to check with my lady if you have any questions. No. That's a very convenient moment. We're going to take 15 minutes now. Will that be all right? Then we'll be hearing from you, Mr. Beard, and Ms. Parkin, and that will give us enough time.
It will. I think I'm going to be slightly longer than Ms. Barton. We've agreed between us who's going to address what.
Thank you very much. 3:20.
It's
So,
like,
in answer to your question,
Yes.
there is nothing which says explicitly that I can find that says the scarf was reviewed. There are, however, references in the currents log to the dash assessment being returned to at various points, so you can, these are the references.
and there is a specific reference to,
And there is
an
reference
early
in,
specific
yeah,
reference
so
to
on the
figures.
6th, there's a review by the Detective Sergeant,
Yeah, there's a secondary
the secondary
review, but
Um, yeah, and
No,
then-
that's, if you want to say that your, you know, your analysis of the documents is that there were not the regular reviews of the SCARF risk assessment, that we've misunderstood that you didn't review it, then, you know, good, because we should have.
you want, is it helpful?
it would be helpful, yeah.
Yes.
Can I have that story?
You have to see it,
I
don't
would eat. I will buy Freddie's supper if we get full disclosure in this case. There wasn't a further risk assessment for you. But hey, gosh, that is really like advocating someone.
Yeah, it's very interesting. Also, they moved the fan. It was on a swirling thing.
Oh yeah.
And then it was,
Justice around the whole family.
oh, nice.
I'm
Do you think
drinking.
it's-
I'm
do you think
actually
it's
don't suffer
appropriate
too
for
much.
us
It's the hair blows.
Is there any chance we could get a bit more water?
You're all kind of dying.
So you can't leave. Can I get water? I guess
Oh,
I
it's
can
actually
get
going to be
from
15.
Where can I get water from? There's nowhere. I'm very thirsty. There must be somewhere we can get water. I'm going to use this water. Is this?
Yes.
I mean, I'm pretty desperate. There must be somewhere. Thank you, thank you. I don't want to faint. Did a hearing of Rachel's hearing? No, Casey. She fainted. She the call was sang too long, and I could see her like drooping. And she just kept her. The car had to come and treat her. There was a thing for the car. There was a collision.
Yeah, I mean, I have to admit, I had one occasion. Is he doing like tour guides? It is very exciting. Just go to the ditch. That was the wrong question. Yeah. You have no diplomacy skills. Yeah, but it's not as bad.
Worse than just not getting it out at all. I always start 2 days before everyone in the classroom. Yeah. To really go see the chief clients.
I'm very disappointed. I didn't catch this person. Frustration has nothing to do with it. I'm sure that one's good fun for you.
We used to all walk towards the bombs, you know. No, look, the bombs had something there. Let's go and have a look and I'll see all the uniforms.
Frustrating. That had nothing to do with fabrics and bosses, but I got pointed out when she's
I'm pretty confident I can go. Didn't Brian ask me a question about the internal appeal process?
Yeah, I'm sure you asked it. I'm sure that's a
That's good. It happened just now. That feels like most of it. As is Stokey Cookie. No, I want to see him. I'm sure I'll run into him. Look, you know, I don't know, maybe the next relevant part is. Down to oh, I see what you mean. We'll stay within the time. think we've got it.
Yes, but no, I mean, how really
Oh,
you
probably
need
15.
finance.
Yeah, fine. You take what you need.
What do you think about me?
I think that's right.
Sweet.
Even back then, weather and music went.
ready. Only me. Very nice of you all, but
Yes, Mr. Beer.
My ladies, my lord, I have 5 points, albeit one of them is a point which is a non-point. I'll take that first. I said that I'd assist the court with references in the cases in which the phrase, quote, in connection with, that we saw in Iqbal was to be found. In fact, Ms. Barton did that for me in her submissions yesterday, so I don't need to do so. I just wanted to tie that loose end off to show that I hadn't...
We're listening.
Yes, I hadn't forgotten. The second point is of more substance. The respondent's formulation by Ms. Murphy as to the scope of any existing immunity or immunities today that she says exist. And she started her submissions today by setting out the limits of the immunity, singular, which she says does exist. She said, number one, she accepted that there is a threshold immunity in relation to evidence given in court and the preparation of evidence given in court, whether in fact that evidence is in the event relied on, but only where the alleged statement constitutes the cause of action relied on. She said, secondly, that that wasn't limited to causes of action in defamation, and she said, thirdly, that the respondent doesn't seek to draw a difference between evidence given in a bail hearing or at a trial. That was her formulation of where immunity sits today. You will note, my ladies, my lord, that in relation to the first and the third point, that the formulation is restricted to evidence given or to be given. And so, as formulated, it doesn't apply to advocates at all, because they do not give evidence at all. They do not prepare witness statements for themselves in readiness to give evidence themselves. That's the first problem with it. The second problem with it is that it entirely ignores the outcome and ratio of Taylor, which Ms. Murphy showed you principally for the purposes of addressing the wholly extraneous issue. What does that mean? When she was showing you that case, she said, incidentally, that it was quite clear that that case was only about witness immunity, i.e. people who were in fact witnesses in proceedings or who would likely become witnesses. We've been to the relevant passage in Taylor twice now. I'm not going to take you to it again. It's 263H to 265C. It doesn't contain anything of the sort that Ms. Murphy contended for. That's why I spent so long yesterday in submissions, taking you carefully through the documents, plural, letters and a file note, to show that Taylor was not about people who were in fact witnesses or who were likely to become witnesses. That's why I spent so long analysing paragraph 40 of Miss Murphy's skeleton argument, where she sought to make the same point, that Taylor was only about witnesses or likely witnesses, irrespective of her motivation for writing paragraph 40. That's why we spent a little time examining who agreed with whom, their lordships. In the course of exchanges with the court, Miss Murphy accepted when pressed, that had the information with which we're concerned, the provision of an address, been conveyed in the form of a witness statement, then the appellants, plural, would be immune from suit. Immune from suit in my client's case in conveying the information to the CPS, and in Miss Barton's client's case in the deploying of the information in open court. We say that's fatal, that concession, to these appeals, i.e. the importance that Miss Murphy places on form over substance. The emphasis of form over substance is entirely inconsistent with the outcome of Taylor, and it's entirely inconsistent with the ratio of it, especially to the passages which I drew attention yesterday. That's why I focused on them so much, because they show that the form in which the information is conveyed is not critical to the operation of the immunity. It's the activity or function that is being performed that is the relevant touchstone.
Sorry, you said the passages yesterday, the passages from...
From Taylor.
Oh, from Taylor, yeah, yeah, yeah.
If you remember, my lord, I took you to the part about the file note, the part about the letters, and then took you to the speech of Lord Hoffman. I've given you the reference a moment ago, where he formulated the outer boundaries of the test. Miss Murphy also accepted that because of what Lord Hoffman said in Taylor, the appropriate outer limit of witness immunity was whether the matter was wholly extraneous to the judicial proceedings. That is a second reason which is fatal to the defence of these appeals. The provision of the name, address and contact details of a witness by an investigator to a prosecutor for the purposes of the proceedings, and which is then in fact employed in court, is not wholly extraneous to the judicial proceedings. Thinking about the form over
sorry,
I'm so sorry.
just saying, I mean, I noted in relation to the bail conditions that they did include the address. I mean, we have that in the note. They did include that the defendant, calling that for these purposes, was not to go to that particular address. So it did result in a bail condition.
Yes. Yeah, so one could draw a direct line between the provision of the information and the outcome of that part of the judicial proceedings. But thinking about this form over substance issue, what about within bail proceedings if the police inform the prosecutor for the purposes of a bail hearing that the victim did not wish to proceed with a charge that's on the charge sheet? That's not contained in a formal withdrawal statement. On Miss Murphy's case, that's not covered by an immunity because the form in which the information has been conveyed is the wrong side of the line. Or what if the police said that the defendant had no previous convictions when in fact he or she did have previous convictions that were relevant to the issue of bail? And bail was granted or granted on the wrong conditions because of the absence of mention of the convictions that the defendant in fact had, and harm resulted to a complainant or a witness as a result.
And she drew the distinction between things that were inaccurate versus accurate things that were said that should not have been said. So her answer to your second example would be, well, it's a cause of the statement is the cause of action. That might not deal with the evidence point, but
no.
What do you say about that line?
Can I address that head on? Because the court asked Ms Murphy whether there was any authority that supported the point that she seemed to make, that here the course of action is not founded on anything provided in the information being untrue. Instead, what was important was what was done with it, which founded the cause of action. That's directly addressed by Lord Justice Morbick in CLG. As my lady's asked the question, we should probably turn it up to look
Thank you.
it. Authorities, Volume 2, tab 35, page 916.
Yes,
It's
we looked at
paragraph
this. We looked
32.
at this, yeah.
We did, but it's well worth redeploying our memory of it in answer to the question that wasn't answered by Miss Murphy. Is there any authority that supported the point that she was making? What matters is the information is true or false in most of the cases. What about if the information is true but it's wrongly deployed? That was exactly the case in CLG. There, what Mr. Gaffney, DC Gaffney, had said was correct. The address was that of CLG and another. That's where the witness summons needed to be served, at their address. It was wrongly deployed. And you'll see when rereading it that it made no difference to his lordship. And so far from...
But this was all about, for the purpose of giving evidence. That will be the second point she makes.
Yes. So far from there being authority to support the point she makes, the answer is no, there is authority from this court against it. If I can continue with the species of information where one might consider whether form matters over substance. The previous convictions point is a particularly good example in our submission because that is definitely necessary for a bail hearing, the previous convictions of a defendant, but also may be necessary for the final hearing. In fact, it's required to be set out on one of the MG forms, MG 16, previous convictions, not for the purposes of the bail hearing, but set out to the CPS for their use in the criminal proceedings. At some stage, perhaps not bail, the police will be required to convey the previous convictions of complainants or witnesses to the CPS. Again, not by witness statement, by one of the MG forms. That's fatal in Miss Murphy's submission because of the means by which the information is conveyed. Or what about for the purposes of a bail hearing if the police provide details of the outstanding evidence or reasonable lines of inquiry to be pursued that are relevant to how long bail should be granted for, whether it should be granted at all? The places of work of the defendant, the places of work of witnesses, information about whom the defendant associates with and in what areas, details of schools, of children, of the defendant, of complainants and witnesses, all information conveyed without witness evidence. The court should not, in our submission, put form over substance. The third point I would wish to make, with the court's permission, is to speak to the reliance by the respondent on their lordship speeches in Dhaka, and in particular, the respondent's reliance on the distinctions that Mr. Justice Ritchie drew based on the speeches of some of their lordships in Dhaka. Just for your note, that's paragraphs 74 to 80 of his judgment. We needn't turn them up, but that's pages 173 to 179. Before I go to those, I should have said that in her submissions, Miss Murphy said that Taylor was, quote, developed in Dhaka, i.e. if something changed as a result of Dhaka to the ratio of Taylor. I've observed already that the ICLR thought that Dhaka simply applied Taylor when they reported it. See page 316 of the bundle. And for the court's note, the passages in the judgments themselves in Dhaka, which simply apply Taylor rather than develop or change it, are 328C, 331F, 335C, 347A, and 352E. If we turn then to the judge's judgment, page 176 of the Core Bundle 1. At paragraph 77.
Yes.
He has cited passages from Lord Hope's speech in his paragraph 75 and 76. And then in his, that's Mr. Justice Ritchie's judgment at 77, in the second and third sentences, it says, if they were preparing evidence for a witness in a trial, that would be covered by the immunity. If they were investigating or enforcing the law, they would not be. This is, with respect, far too broad a statement. It focuses in its first part on preparing evidence for a witness. And it doesn't address when an officer may be investigating or enforcing the law. The judge continues, the actions of the police passing on XGY's confidential address were extraneous to the evidence in the bail application or the main trial for assault. This is, with respect to the judge, almost impossible to understand. What does he mean by extraneous to the evidence in the bail application? In relation to Lord Cook's reasoning,
I used to know this once upon a time, but Darker came out 7 days after Hall, but makes no reference to Hall.
that is true.
Has anything been written about that? There's so many articles about all of this.
I
Anyway,
can't.
nothing on that point. Doesn't matter. As a
No,
matter of fact,
I-
for whatever reasons.
The straightforward answer would be I don't know, and I'm not going to
No, speculate.
give an answer either way where I don't know the
No,
certain position.
No.
Turning to what Mr. Justice Ritchie made of Lord Cook's reasoning, it's the middle of page 38 of the judge's judgment, on page 178. Starting with the sentence, on the basis of this ruling, that no immunity attaches to actions which do not form part of the evidence to be given at trial. The bail hearing file prepared by the police was arguably extraneous. It's again not clear with respect to the judge where he got this from. Ms. Murphy described, I think, this passage as unimpeachable. The passage immediately before it refers to evidence given in the judicial proceedings. Can you see that? The passage from Lord Cook.
Judicial process.
Yes, process, not proceedings, quite right.
And Lord Clyde. Not Cook, I think.
Yes, Lord Clyde and Lord Cook on the previous page.
Yep.
It's unclear why it should be restricted to evidence given at trial, even in the light of these authorities. And in any event, the policy reasons for the existence of the immunity apply with equal force to information passed to a prosecutor for use in the pre-trial stages as much as they do for use at
But I
trial.
think Miss Murphy accepts that.
Yes, I think so, yes. The judge returns lastly on this point to his theme at the at paragraph 80, right at the end, on page 179. I accept it was arguable that XGY's confidential address was not evidence in the rape case, proved nothing of the crime, was irrelevant to the bail hearing, and it was extraneous. Not evidence in the rape case in the first place. Why must it be evidence in the rape case? Prove nothing of the crime. This is a new additional requirement that the judge has added in himself. Why is it necessary for the relevant information, even if it is evidence, to be probative of the crime? What if it was exculpatory? was irrelevant to the bail hearing. As I've said, we were required to provide this information to the Crown Prosecution Service as part of the case file, and it could have been relevant to the bail hearing, as in fact the prosecutor decided it was. It was extraneous, his last reason, but why? There are a range of reasons why an address has to be provided, irrespective of how it was in fact deployed in this case. More generally, the outcome in DACA and the ratio of it is entirely different to the present situation on two main bases. That's well explained by Lord Justice Moses in SMART and the FSS, which I just invite you to turn up. Authorities, Volume 2, tab 30, page 795.
Can we put the judgment away?
I'm so sorry?
Can we put the judgment away?
Yes, you can. Thank you.
Paragraph 30.
Paragraph 25.
No, sorry.
Tab.
Tab 30. My Lord's correct, but it's paragraph 25. And I'm diving straight in because, in fact, I don't think the facts matter. And if you read in his Lordship's judgment, halfway through paragraph 25, he says, in DACA, and then just to the end of the paragraph. So the base facts were the planting of evidence. That's what DACA was about. And that had two consequences, each of which was critical to the outcome, as Lord Justice Moses says, and each of which are entirely absent here. The court will observe, no need to turn it up now, but crucial to the outcome of SMART was the fact that the Court of Appeal had allowed the appellant to add a claim of deceit. And that was therefore the end of the matter because it completely, that's paragraph 27. Now we've allowed the amendment. The rationale for conferring witness immunity has gone, etc. But lastly, in this point, I need to deal with Ms. Murphy's reliance on the Court of Appeal's decision in Daniels. She said that it was determinative of the appeal insofar as concerns the Chief Constable. This is same authorities volume, tab 34. And if we can pick it up on 897. The heading discussion. And the point that I'm essentially going to make to the court is that there were two features which meant that the Chief Constable, which meant that I was not successful in Daniels. The first reason is found in paragraph 46. The proposed claim for misfeasance is not founded on the content of any express or implied statement associated with the service of the schedule of unused. On the contrary, the substance of the complaint relates to the way in which the disclosure exercise was performed. So it's a DACA type case where in DACA they were concerned with planting evidence. Here the court was concerned with destroying or concealing evidence. That's the first distinguishing feature from this case and the reason why we failed. What was complained of was the deliberate hiding of documents in a disclosure exercise. What was not complained of was the way in which the information was conveyed to the prosecution, the defence, or to the court. But in this case, the present case, there's no separate act like this. There is no separate act which happens to be described in a document. So Daniels was like Darker about the planting of evidence or the destruction of documents, not about the description of doing so in communications to the CPS or to the court. Then the second reason why this case on analysis doesn't assist my learned friend is from paragraph 47 onwards. The second difficulty arises, etc. And essentially you'll see that it's an allegation of the fabrication of false evidence or similar. As Lord Justice Moses had identified in Smart, once that type of allegation was made, the complexion of the operation of the immunity changes. My fourth point is the respondent's position on whether or not she mounts an attack on the core immunity of the advocate for things said in court, and establishing exactly what the respondent's position on this has proved to have been a rather quixotic endeavour. You'll see that when the Bar Council came independently to these papers afresh, it struggled to work out whether a head-on challenge to the core immunity of the advocate for things said in court was or was not being maintained. Ms Barton is going to develop the substantive response to this point, but the procedural one is that before the judge, as has been observed, there plainly was such a head-on challenge. For the court's note, that's the judge's paragraph 42, core bundle 156. The appellant submits there's no such thing as advocate's immunity, whether at court or before court. The judge's paragraph 47 at page 158. In support, she submits that the Supreme Court swept away advocate's immunity at court altogether in
Well,
Hall.
that has been repeated today,
Yes.
as I understand it, yes.
Yes,
So
the
that-
judge, I'm just simply
Okay.
fleshing out the point at which this issue arrives before this court. So it was plainly an issue before the judge. As has been observed, the judge rejected that part of the respondent's appeal. Paragraph 85 of the judgment, paragraph 103, paragraph 133. As we've both said in our skeleton arguments, and we repeat today, the respondent's notice does not include any such head-on challenge to the existence of the core immunity of the advocate for things said in court. As I say, Ms Barton is going to develop a more substantive response to that. If I can just footnote, however, the court asked the question of Miss Murphy, has it been recognised in any post-Hall cases that the outcome of Hall was the abolition of the immunity entirely, not simply in relation to the advocate's client? Well, in fact, the answer is that it has been considered,
Yes,
but rather the other way round.
yes, I picked that up as well from
If we,
A and B, I think, or is it C?
yes, I mean, one could start with A and B
Yeah.
at paragraphs 26 and 27. That's authorities 7, 8, 9. Mr. Justice Spencer, but one could move to El Haddad and Al Rostomani, my mistake. Mr. Justice Fancourt, his paragraphs 90 to
But he
96.
states that it's limited, but was there a challenge to that?
Yes, he
In that case, that he was dealing with the same submission, was he?
roughly the same submission, yes. And similarly, Mrs. Justice Cockerell, in King and Stiefel, paragraphs 319, 325, and 333. They're all first instance decisions, but I provide them simply to assist the court in answer to the question that was not answered. Can I come to my fifth point, which is my end point? I said at the outset of these proceedings that we were being live streamed with a delay, and that was to protect against the possibility that any of the advocates in this case made a slip-up.
Did somebody?
Sorry?
Was there any slip-up?
No, there wasn't. But it
You
was...
had me worried there for a moment.
No. It was to protect against the possibility of a slip-up if we disclose the name, the address, or some other identifying feature of XGY. And that's primarily for her benefit. But on the judge's ruling, we, the advocates in court, and the clients who instruct us, who provide us with the information that would have allowed us to make that slip-up, would be exposed to a liability and damages had we done so. None of us, the advocates before you, are giving evidence. We're making submissions. None of us, the advocates before you, are referring to the evidence that is being given in the course of this hearing, because there is none, or is to be given at a trial. We're making submissions. We're not a trial, we're appellate proceedings. On the judge's ruling, our mistaken disclosure would be extraneous to and outside any immunity. On the judge's view, the imposition of liability would help to improve the quality of our advocacy, in that it would make us think twice before disclosing information to the court mistakenly. One only needs to reflect on those possibilities to see why, with respect, Mr. Justice Ritchie went seriously wrong. Can I assist the court any further?
No, thank you very much indeed, Mr. Beer. Yes, Miss Barton.
My lady, can I start by saying that, of course, it's always uncomfortable for a court where something has gone wrong and there appears to be no remedy. But that has been a recognised facet of advocates' immunity, indeed witness immunity, right through the thread of the authorities. In this case, in fact, as a result of the disclosure, the particular problem was the escalation of risk. And the remedy there is to deal with that escalation of risk immediately in a way that was in fact dealt with. And in this case, the perpetrator was prosecuted successfully and imprisoned. The fact is, as the authorities have made clear, that the immunity is not in place to protect those who have done wrong, but to protect those who go about their business in court in good faith from vexatious litigation. And it continues to be a necessary protection. I agree with and adopt, if I may, the submissions made by my learned friend, Mr. Beer, particularly in relation to the form versus substance argument, and specifically in relation to the concession which was made by Miss Murphy when she agreed that, when pressed, that had the information been conveyed in the form of a witness statement, then the appellants would have been immune from suit. And we respectfully submit, as did Mr. Beer, that that is fatal to this claim, because the immunity is not dependent upon the form in which any information was conveyed. It is dependent upon the substance of the information. Dealing, if I may, briefly, because this was material which I covered very thoroughly, I hope, in my original submissions.
Yes, well, there's no need to repeat anything, but reply to any new points, points that you didn't cover, as it were.
I will. The position in relation to the advocate's immunity being swept away is, we submit, wrong. It's simply unsustainable on the authorities. To deal with the point which my lady raised about the Darker and
Yes.
Hall and Simon's cases, it may be of assistance to note that, in fact, there was some commonality in terms of the judges who sat on those cases.
I know.
And so
Beyond Lord Hope, what was the overlap?
Lord Hutton.
Right, Lord Hope, and yeah.
Both of whom, in both cases, made significant speeches about the extent of the immunity. And one would have thought and expected that had the immunity being swept away in Hall and Simons, that would have been said, and advocates would have been invited to make submissions upon it. That didn't happen. And more importantly, in both cases, Lord Hoffman in particular there referred to the well-established rules that judges, counsel and parties are all absolutely immune. Now, in respect of counsel's immunity, if it had been swept away, that would have been a surprising approach to take. So we say that it is simply unsustainable as an argument to suggest that the advocate's immunity, whatever the scope of it, has been swept away completely by Hall and Simons or Jones and Caney. Now, in terms of the effect of that, as my learned friend's already gone to, and I won't take you to them, but it is important, the three modern cases at first instance are important because they engage that issue without anyone ever suggesting the immunity has completely disappeared. So far as the Crown Prosecution Service are concerned, in response to my learned friend's, Miss Murphy's submissions about the reasons why the immunity does not attach to the Crown Prosecution Service, she says, well, the cause of action must be linked to the content of the statement or action within the court. In this case, our submission is one, that is not a requirement, because when one looks at the nature and extent of the causes of action that have arisen over the years as a result of what is said or done in court, it is not always the case that it relies upon the content of the words spoken or acts done as wiping out the cause of action. What is important in our submission is whether the cause of action is founded on what is said and done in court. Will the cause of action stand or fall on what is said or done in court? That is, in our submission, the test. And the reason for that is because if one could maintain an action quite independent of what was said or done, then it might be arguable that the immunity does not apply. But where the action absolutely hangs on, and can only hang on the words spoken or acts done, then the immunity bites. And not only does it bite, but those actions sit right at the centre of that immunity. And so we say in response to my learned friend that it's a distinction which she attempts to make, but it is a distinction without substance, because once one looks at whether a cause of action can be maintained without reliance on what was said or done, one can see that even her formulation of words would still catch the act or omission within the immunity. So in terms of the position of the Crown Prosecution Service, we say in response to Miss Murphy's submissions that one, she made a concession which is ultimately fatal. Two, that the argument that advocates' immunity has been swept away is simply unsustainable. And for the reasons which I articulated yesterday, advocates' immunity does sit separately from witness immunity, although it shares many of the same public policy features in terms of the rationale for its existence. As my learned friend Mr. Beer says, it's not a case that advocates are in a position or ever give evidence in a case So it's not an evidential witness immunity. Save in cases where they're called as witnesses, witness immunity isn't going to attach. So what we say, what we maintain is that witness immunity is separate, advocate's immunity is distinct. We can see that from the cases, and that the Crown Prosecution Service sits in the centre of that immunity on the facts of this case, and that the distinctions which Ms Murphy has sought to make are not of substance, they're of form, and they have no effect on the immunity.
Thank you very much indeed. Ms Collar, I don't think you have a right to reply. Do you have any questions? No? Thank you. Well, that concludes the submissions in this very interesting matter. We are acutely conscious of the delay in the sense of how long ago these events happened, and the trial on the Epsom disclosure is presumably still in the wings waiting.
It is, my lady.
Yes. All that said, obviously we've got a great deal to digest and think about. We will produce a reserve judgment. That means we're not going to give judgment today. We're going to hand down a judgment in writing, in draft in the first instance under an embargo, then to be handed down. With the best will in the world, I don't think we're going to manage that before the end of term, simply because of the amount of authorities and information and submissions that we've heard. I would hope that we will be able to have something with you by the beginning of next term. That means the beginning of October. If for any reason there is a problem with that, we will keep you informed. Are there any particular dates or factual matters that you need to draw to our attention in this context?
No,
thank
my
you.
lady. And may I say, on behalf of the respondent, that it is actually very much appreciated that the timetable has been indicated, and we do appreciate
No,
that.
well, we do
complex
understand
complicated
how
issues.
stressful these situations are, and we understand the broader importance of some of these issues. But of course, at the heart of the litigation stand the parties themselves. So we will now rise. If we need anything more from you, I can promise you that we will get in touch. But I think we have everything we need at the moment. Yes, thank you. And all that remains is for us to thank you both for the written submissions, for the careful presentation of all the bundles, and that would have involved not only the front or even the second row, but also those sitting behind all of the advocates in this case. It's been a great pleasure to receive all the submissions, and we look forward to making our decisions and writing our judgments. Thank you very much indeed.